Chapter 2, Public Official Bonds, Sec. 20. Scope. The bonds that will be next considered are those required by law to be given by persons holding positions of public trust. They are known as public official bonds, and this title includes the bonds of officers of the United States, of the states, of counties, municipalities and other political subdivisions. Sec. 21. Form of bond and liability in general. There is a marked difference between the liability on a public official bond and that on a fidelity bond. We have seen that a fidelity bond covers only certain specified acts on the part of the employee, such as fraud, dishonesty and the like, and that the bond is usually subject to certain conditions limiting the surety's liability. A public official bond, on the other hand, generally guarantees the faithful performance by the officer of all the duties required of him by law, and as a rule cannot be made subject to any restrictions upon the liability of the surety. The surety is liable, therefore, not only for any public money the officer may convert to his own use, but also for any loss resulting from the failure of the officer to perform his duties or from the negligent or improper manner in which he performs them. It is to be borne in mind, in this connection, that as a rule it is not feasible or useful to put in the bond as a conditions limiting the surety's liability as fixed by law. Such a bond would probably not be accepted, and if it were, the conditions would probably be declared void by the courts. Although some states sustain the validity of such conditions, most of them do not, and, as a general proposition, if a bond is not a good risk on the statutory form, it should not be issued. Sec. 22. Termination of liability. The bond of a public officer generally covers the full term for which the officer was elected or appointed. And, inasmuch as the bond is a contract between the principal and the surety, on the one hand, and the people of the state, county or city, on the other, it is clear that only the people, acting through their law-making body, can relieve the surety of his obligation during the term. The fact that the principal may be willing to give another bond, or that he may neglect to pay the annual premium, provided for in his contract with the surety, can have no effect upon the surety's liability. In some states, there is a statute, under authority of which, the surety on certain public official bonds may obtain a release from future liability. Such statutes are extremely useful when a risk which appeared in the beginning to be good, turns out to be undesirable, and they no doubt lessen the chance of loss. Sec. 23. The underwriting of public official bonds. We are now prepared to take up the main object of the chapter, namely, the question when these bonds may be written and when they should be declined. In doing so, we will follow the general plan that was adopted with reference to fidelity bonds. That is to say, we will not attempt to treat specifically the risk on each different bond or class of bonds, but will point out the more important risks or chances of loss to which sureties on public official bonds generally are subject, and thereby reduce the matter to general principles, so that the underwriter may, in the light of those principles and the law of the particular state, accurately determine the risk in any particular case. The surety on a public official bond, like the surety on a fidelity bond, may be in danger of loss either because of something in the personality of the principal or because of the nature of the duties he will be required or expected to perform, and the subject will be treated from those two standpoints. Sec. 24. The personality of the applicant. In general, we have seen that in considering the personality of an applicant for a fidelity bond, it is necessary to be satisfied only that he is honest, for the only obligation of the surety is to see that the principal does not fraudulently misappropriate the money or property of the employer. But the surety for a public officer is bound, not only to see that the principal does not personally misappropriate any of the public money in his custody, but that he fully performs the duties required of him by law. It is necessary, therefore, to investigate the personality of the applicant from the standpoint of his efficiency as well as his honesty. Sec. 25. Honesty. In attempting to ascertain whether or not an applicant for a public official bond is personally honest, the same general principles will apply as in the case of fidelity applications, and reference is made to the appropriate sections. However, it is not always practicable to require a complete record of the past employment of the applicant, so that the only available sources of information are the applicant himself, the persons to whom he refers, and such personal knowledge as the surety company's representative may have or may be able to get from outside sources. In making the investigation through the references, the suggestions that have been made regarding fidelity applications will be applicable. But the most reliable information is not to be obtained from the references, who are likely to be the applicant's close personal and political friends. In the course of political campaigns, the record of the candidates generally becomes public property, so that if the surety's representative is alive he will not have to rely upon the statements of applicant's friends, but will have the views of his political enemies as well. There is really no excuse for ignorance on the part of an agent as to the standing of an elected officer, and appointees to offices of any importance are generally well known too, so that by making inquiries here and there, reliable information can be obtained without depending upon the references. Sec. 26. Efficiency. We have seen that, because the surety for a public officer is liable for the faithful performance by him of his duties, it is necessary to be satisfied that he is reasonably qualified to perform the duties of the office. It is not, of course, necessary that he should be familiar with the details of the particular office, nor that he shall have been trained in that particular work. But, as a general proposition, where a man is taken directly from the farm or the workshop, with no training in business or in accounting, and put in charge of a public office where he will have large sums of money to handle, or other duties for which he has had no training, the result is not likely to be satisfactory. His business methods are apt to be so lax, and his books kept in such poor shape, that it will be difficult for him to tell where he stands. He is likely to get personal and public funds mixed, and, inadvertently perhaps, to use some of the latter for himself, and he is likely to make errors of one kind or another resulting in the loss of public money, for which he will be held accountable. The matter is a very important one, for it is well known that public officers are selected much less for their fitness than for their popularity or political influence. Large and important offices are generally filled by men of intelligence and a fair business training, and moreover, in such offices there is usually a deputy upon whom the actual management of the office falls, and who has been holding office from term to term and is thoroughly qualified. The principal danger from inefficiency lies in the smaller offices in the country, where a man with little or no education and absolutely no clerical experience is elected or appointed to fill an important office such as county treasurer, tax collector, or sheriff. It is difficult to say when it is necessary to decline an application because of the supposed inefficiency of the applicant. The most that can be done here is to call attention to the point, and to suggest that a bit of common sense be used, taking into account the duties and liabilities incident to the office and considering whether the applicant has the experience and training that will reasonably fit him to fulfill those duties and protect himself against the liabilities. Sec. 27. Financial resources. If an applicant happens to be well fixed financially, that fact will, of course, operate in his favor in the consideration of his application, as a man who has something to lose can generally find a way to conduct his office so as not to subject himself to any liability. However, the application should first be considered entirely apart from the question of the financial worth of the applicant. If a careful investigation shows him to be honest and qualified to fulfill the duties and obligations of the particular office, the risk may be accepted regardless of his financial worth. It is only where the applicant does not strictly measure up to the requirements that his finances are to be considered. However, if a man does not appear to be reasonably free from suspicions of dishonesty, a surety company ought not to go on his bond, even though he may be reputed to have money. But where the defect lies in the question of his ability to fill the office, then the fact that he is worth a substantial sum may be permitted to turn the scales in his favor. In view, however, of the fact that a man's net worth is difficult to ascertain and that men often live and act as if they are well fixed when they are in debt, the supposed wealth of an applicant should not be given too much weight. Sec. 28. The nature of the office. In general, in order to determine whether or not an applicant has the proper qualifications for the office in question, it is necessary to consider the nature and extent of the duties of the office, as well as the opportunities, temptations and liabilities to which the applicant will be subject. In treating the matter here, we will, in accordance with the plan previously outlined, make no attempt to enumerate the duties, liabilities, opportunities and temptations of each particular office, or even of each particular class, but will treat these matters with reference to public offices generally, so that the underwriter may be aware of the possible dangers and look out for them in each case. Reference will be made especially to those hazards which the surety may have an opportunity, before signing the bond, to make arrangements to lessen or avoid. Sec. 29. Opportunities, temptations and liabilities. In general, in determining the hazard on a public official bond, from the standpoint of the character of the office, the first thing that naturally presents itself for consideration is the nature and extent of the opportunities and temptation that will be afforded. Generally, these elements are present in direct proportion to the amount of money the officer will handle, the ease with which it could be converted to his own use, and the probability that a conversion could be concealed for a considerable length of time. The matter will be treated from these three viewpoints, and then we will take up the matter of liabilities. Sec. 30. The amount of money to be handled. It is, of course, apparent that the opportunity of a public officer to misappropriate public money, and the temptation to do so, are in direct proportion to the amount of money he will handle and the amount he will have on hand at any one time. Likewise, the chance of loss as a result of the negligence or incompetence of the applicant or the acts of his clerks or third persons is in proportion to the amount of money to be handled and the amount likely to be on hand at one time. While it is hardly ever necessary to decline an application merely because the applicant will have the custody of large sums of money, yet, where the amount is large, it becomes the more essential to make adequate and proper provision for its safekeeping, and the matter of the efficiency of the applicant becomes more important. Sec. 31. The system of checks. The next point for consideration is the ease or difficulty with which the applicant could convert public money to his own use. It is, of course, very seldom, if ever, possible to so arrange matters that an officer having the custody of public money could not convert it. But anything that tends to check the freedom with which he could do so, without being immediately discovered, is a safeguard. Where the bulk of the money that comes into the office is in cash, and where the cash is directly handled by the officer himself, and is dispersed on his sole order, the opportunity is greatest. And the opportunity is lessened to the extent that the money is paid into the office by checks so drawn that the officer will likely have to deposit them to the credit of the state, county or city, as the case may be, to the extent that the money is handled, not by the officer himself, but by deputies and clerks, who are bonded, and to the extent that countersignature is necessary in order to withdraw money from the depositories. It is not always necessary for a surety underwriter to accept or reject an application as it stands, as the suggestions of a surety company looking to an improved systems of checks are often welcomed and adopted. The checks above named, and any others that may suggest themselves in particular cases, should be applied as far as possible, and if the checks that will be applied are not reasonably efficient, then the requirements as to the personality of the applicant must be strictly enforced. Sec. 32. Ease or difficulty of concealing shortage. It is seldom that an officer misappropriates public money if he knows or has every reason to believe the defalcation will soon be discovered. He generally yields to the temptation either under the assumption that he will be able to pay it back before the shortage is discovered, or that he can conceal the shortage so effectually that it will not be discovered at all. Where there is to be no audit of the office, there is little or no difficulty in concealing a shortage, and almost any officer who handles money could, under those circumstances, take some of it without being discovered until the end of his term. But the opportunity to conceal differs in different cases, and in each case the circumstances should be noted in the light of the following principles. A. The opportunity is lessened where the officer is required periodically to account for and pay over the balance in hand, and is not permitted to continue throughout his term to retain all public money received less that expended. There may be nothing to prevent him from neglecting to account for some of the money, but the fact that an accounting is necessary is a safeguard, and if the accounting is required with reasonable frequency, say once a year, and is required to be in full of all funds received to date, the bond may be written without regard to the financial worth of the applicant, so long as his personality is up to the standard. But where no such accounting nor any satisfactory audit is to be made, it is generally best to decline the business unless the applicant has some financial responsibility. at least equal to 1/4 the penalty of the bond. This, however, may be waived where the personality of the applicant is in all respects up to the highest standard. B. Where, although he is required to make annual accountings, yet, before he is required to account for the first annual fund, he begins to receive the second, so that a defalcation out of the first year's fund could be made up out of the second, the good effect of the accounting is nullified. This principle is illustrated in the case of tax collectors, where they are not required to account in full for the taxes collected during 1 year until after they begin to collect for another year. Such an officer could carry along a shortage for an indefinite period, and the matter should be considered just as if no accounting were required. C. Likewise, where the officer is the collector or custodian of 2 or more different funds and is not required to account for all the funds at the same time, so that he could use the balance of one to pay up the other, the good effect of the accounting is nullified. This is illustrated in the case of tax collectors who, for example, collect county and school taxes and make their accounting for school taxes at one time and for county taxes at another, so that they could use second year's collection of one to make up a shortage in the first year's collection of the other. In all such cases, the matter should be treated just as if no accounting were required. D. The opportunity is lessened where, though the officer is not required to account, there are certain times during the year when the expenditures will nearly equal the receipts, so that there will be only a nominal balance in hand. In that event the officer cannot, without being discovered, take more than an amount equal to this balance. Inasmuch, however, as the size of this balance cannot be definitely known in advance, and may be quite large, it is not well to put much dependence in this supposed safeguard. Sec. 33. Frequency and efficiency of audits. As a matter of fact, public officers do not generally have such unrestricted opportunities and temptations as those outlined in the last section. In nearly all states, counties and cities there is an auditor of public accounts who is expected at certain intervals to audit and examine the different public offices under his jurisdiction. This is an important safeguard, for it is seldom that a public officer misappropriates a large sum at one time. He generally begins by using small amounts with the intention perhaps of replacing the money at the first convenient opportunity. If, therefore, any peculations of an officer are likely to be discovered by an auditor soon after they have started, the risk of the surety is greatly lessened, for the probability of discovery operates not only to prevent large losses, but is instrumental in preventing any loss. In considering applications for bonds of officers who handle public money, investigation ought to be made to ascertain if there is an auditor in the particular jurisdiction, how frequently the particular office will be audited, and the standing of the auditor and his reputation for efficiency. If there is no auditor, or if efficient audits will not be made at least once a year, the bond should be written only if the personality of the officer measures up to the highest standard, or where the applicant has considerable financial responsibility, at least equal to 1/4 the penalty of the bond. Poor audits may be the result of the fact that the law does not give the auditor full power and authority to make the audits or does not provide the requisite clerical assistance, that the auditor has not the requisite ability, or that he belongs to the same clique of politicians as the officer whose accounts he is to examine, and may therefore fail to discover evident irregularities for fear of its effect upon the party. These several aspects of the matter should be considered in each case. In considering the probable efficiency of an audit, it is well to bear in mind any special difficulties there may be in making an accurate check. Where, for example, the officer is the collector or custodian of 2 or more different funds, each of which will be audited by a different auditor at a different time. The officer could exhibit the same money as the balance of each fund, so that a shortage would not necessarily be discovered. It is necessary that a complete audit of all the funds be made at one time and that the officer be required to show at the one time the total or aggregate balance of all the funds. If this is not to be done, the audits will not amount to anything and should not be considered. So also where it is difficult or impossible to tell what funds have come into the hands of the officer, an audit will not be effective. This is true to a greater or less extent in practically all cases, and shows the importance of not relying too much on audits, and, in some cases, an audit is of no value whatever. Take the case, for example, of a tax collector who is not required to account fully for the first year's taxes before beginning to collect for the second year. It is generally an easy matter in that case for a collector, who is short, to deceive the auditor by reporting that he has not collected certain taxes which in fact he has collected. In general, it may be said where it is not possible to check the receipts of the officer, it is not well to put any dependence in an audit. Some companies deem it profitable to have their own auditors go out periodically and audit the accounts of the public officers whom they have bonded, and verify the cash balance. Such a checking no doubt prevents many losses, but it is expensive, and other companies, realizing that audits are not always effective to prevent losses, think it more profitable to be more conservative in underwriting and to pay the losses that might be saved by the audits. We are not concerned here with the advisability of making such audits. The point is that such audits are likely to be at least as effective as audits by public auditors, so that where private audits will be made, the underwriters do not have to concern themselves so much with audits at public expense. Sec. 34. Where applicant held the office during the preceding term. Where an officer serves for 2 or more successive terms, and has a bond with different sureties for each term, the sureties on the bond for the last term are liable for all money in the hands of the officer at the time of the execution of the bond, and it will be presumed that the principal had in his hands, at that time, all the money that he ought to have had. In other words, where an officer is short at the end of his first term and applies monies coming into his hands during the second term to the payment of that defalcation, the surety on the second bond will be held liable for the defalcation thus made during the second term. It appears not to be difficult for public officers to conceal a shortage, and therefore, when a new surety goes in for a second term, he may not only be bonding a man who has defaulted, and who therefore may be expected to do so again, but actually assuming liability for an existing shortage. As a rule, therefore, holdovers who handle money are and should be on the prohibited list, and the prohibition should not be waived unless the applicant is worth, in net available assets, an amount at least equal to half the penalty of the bond, or unless there is convincing evidence that there is no existing default. The evidence, as to the correctness of the accounts, should be based on a genuine audit of the books and accounts of the officer by an expert accountant and an actual verification of the cash shown by the books to be on hand. And it should be borne in mind that unless it is practicable to tell exactly how much money has come into the office, the audit will not be satisfactory, and in that event the bond should not be written unless the applicant is worth an amount at least equal to half the penalty of the bond. Sec. 35. Liabilities for loss by bank failure. Let us now consider some of the liabilities to which public officers are subject, and against which they and their sureties should be protected. One of the duties of a public officer is to account for and pay over all money that comes into his hands, and when he gives bond for the faithful performance of his duties, he and his surety become insurers that the money will be paid in accordance with law, and generally no excuse, except such as may have been specifically provided for by law, will avail to relieve the principal and surety of this responsibility. If therefore the bank in which the officer deposits the money under his control should fail, the officer and his surety would be liable for the resulting loss, notwithstanding care had been exercised in the selection of the bank. In recent years, many states, counties and cities have provided by law for the selection of depositories for their funds, have required these depositories to give bond for the safekeeping and proper payment of the funds on demand, have required officers to put funds under their control in these depositories, and have relieved the officers of liability in case of the failure of such banks. In order, however, that the officer and his surety may be thus relieved, it is absolutely necessary that the depository law be strictly complied with, that is to say, the depositories must be selected or designated in exactly the manner pointed out by the statute, and they must give bond and otherwise qualify exactly as fixed by the statute, and they must not have on deposit at any one time an amount in excess of that for which they can legally qualify as depositories. The fact that strict compliance with the law may have been waived by some officer, or not required, does not affect the case, for the loss will fall on the officer and his surety unless every detail of the statute is complied with. In this connection, it should be borne in mind that there are some so-called depository laws, which do not make it obligatory upon the officers to put the money in the designated banks, and, therefore, do not relieve them of their ordinary liability. These laws have not been referred to in the note. If there is no law which provides public depositories and relieves the officer of depository liability, or if the law which exists has not been strictly complied with, the surety should require the officer to demand of the banks, in which he will deposit the funds under his control, a bond, with an acceptable corporate surety in favor of the officer and his surety, conditioned for the safekeeping and proper payment of the funds on demand. It is not considered good policy for a surety company to carry the depository liability on a public officer without being compensated therefor, or obtaining adequate protection, in the manner above indicated, and in order to avoid carrying too much liability in one place, it is advisable to let some other company carry the depository liability. Sec. 36. Defaults by subordinates. For the same reason that an officer, unless specially relieved, is held liable for a loss resulting from the failure of a bank in which he has deposited public money, he is also held liable for a loss resulting from a default on the part of his deputies or clerks. In some cases, the deputies and clerks are themselves required by law to give bond for the protection of the state, county or city, as the case may be, and that would indicate that the officer would not be held liable for a default on their part. But, where they are not required by law to give bond, and where the officer is liable for their defaults, he should require them to give regular fidelity bonds, so as to protect him and his surety from that liability. A surety company cannot afford, for one premium, to assume a risk of default by more than one person. Sec. 37. Loss by burglary, theft or larceny. A public officer ordinarily would not be relieved of his duty to account for money that had come into his hands, by the fact that it had been taken from his custody by a third person. While it is bad judgment for an officer to keep any substantial amount of public money on hand, yet it may sometimes be unavoidable. In that event, the money should be kept in a good safe, and he and his surety should be further protected by burglary insurance on the safe. The premium for the officer's bond does not compensate for this risk, and where the applicant declines to comply with the surety's requirement in this respect, the bond should not be written, unless the financial resources of the applicant are deemed sufficient to take care of any probable loss from this cause. Sec. 38. Liability for interest derived from public funds. It seems to have been quite the custom, a few years ago, for public officers to appropriate to their own use the interest earned on public funds, and it appears to have been considered proper in many cases. But now the courts hold that a public officer is required to account for any interest that he may receive on loans or deposits of public money. It is important therefore to ascertain that an applicant for a public official bond does not consider this a legitimate subject of graft, but that he recognizes his obligation to account for any money that may be received from this source. Unless proper provision is made by which the public will receive the interest, the bond should not be written in the absence of adequate financial responsibility on the part of the applicant. The fact that the use of the interest by the incumbent of the particular office may have been acquiesced in by the public for a long time is not sufficient to justify its continuance. For there are cases on record where the surety for a public officer has been called on to make good the interest on public funds received and used by the officer, and this, notwithstanding the fact that the officer had long since retired from the office and the use of the interest by him had been apparently considered proper by those who at the time were aware of it. Sec. 39. Neglect or malfeasance of official duty. We have been considering public official bonds from the standpoint of the liability of the surety for public money that comes into the hands of the officer. But the surety is liable also for the failure of the officer to perform his duties or for the improper performance of them, although of course there can be no recovery against the surety unless the neglect or malfeasance of the principal results in financial loss either to the state, county or city, or to some third person who has a right to demand the proper performance of duty by the officer. The best illustration of the possibilities of loss from neglect or malfeasance is furnished by tax collectors. As a rule, a tax collector is furnished, at the beginning of the fiscal year, with the tax roll and is required, within a certain time either to collect the taxes listed on the roll or make a satisfactory explanation of his failure to do so. In some states, his mere affidavit to the effect that the taxes are uncollectible will be accepted, and on such affidavit he will be relieved from liability. In other states, his statement of uncollectible taxes is subject to review by another officer, and if the other officer is of the opinion that some of the uncollected taxes, by the exercise of due diligence, might have been collected, or if he thinks the collector has not used all the means provided for by law for making the collections, then the collector will be charged with, and required to pay, the amount so found to be collectible. It is evident that a surety company should not take any such risk, so that unless the collector can be relieved of liability for uncollected taxes by making an affidavit that the uncollected taxes are uncollectible, or by other similar means, the bond is not a legitimate surety proposition and should be declined, unless perhaps the applicant is very strong financially, worth, say, an amount equal to half the penalty of the bond. In determining how the collector is to be relieved of liability for uncollected taxes, it is not safe to rely upon custom not supported by law, for a change in the political complexion of the administration very often brings about a change in such customs. Another illustration of the possibilities of loss from neglect or malfeasance is afforded by clerks of courts, recorders of deeds, and the like. If such an officer, or any of his clerks, should inadvertently fail to enter a judgment or to record a legal paper, or should do so erroneously, and such error should result in loss to a third person, the officer and his surety would be liable for such loss. Such bonds should not be written unless the applicant is an intelligent man and is familiar with that character of work. Bonds of this kind cannot safely be written for men who, though honest, have not the experience and training that will enable them to do the work successfully. In large offices, where an experienced deputy is to be in active charge of the work, this point is not so important, but the principal danger lies in small offices, where the officer himself is to be in active charge of the work, and where, by political influence, an ignorant man nor one with little or no clerical experience is elected or appointed to fill the office. Without attempting to go into this point in further detail, it may be said in general that wherever an officer is required by law to perform duties, the neglect or improper performance of which will likely result in financial loss either to the state, county or city, or to a third person who has a right to demand and expect the proper performance of duty by the officer, the risk of the surety is more than an honesty risk and partakes of the nature of a financial guarantee. Such bonds should not be written unless the applicant is thoroughly familiar with the character of work he will be called upon to do. If there is any reasonable doubt on this point, a fair amount of financial responsibility is requisite, an amount equal to 1/4 the penalty of the bond. Sec. 40. Acts in excess of authority. Another way by which a public officer may impose a liability on his surety without misappropriating any money is by exceeding or abusing the authority conferred upon him by law. However, an official bond is not regarded as imposing a liability on the surety for the purely personal acts of the officer not done as a part of, or in connection with, his official duty, as, for example, the receipt of money which it was not the officer's duty to receive, or the arrest of an individual, or the seizure of property, without a warrant. But in most states, acts done under color of the office are regarded as acts for which the sureties are liable. Thus, the surety is liable, where an officer, having an execution, seizes the goods of one person when the execution is directed to another, or having a warrant, arrests the wrong person. United States Marshals, sheriffs and constables, whose duties include the service of process of the courts, are the chief offenders in this respect, and before executing bonds of this class, it should be ascertained that the applicant has sufficient intelligence, knowledge and discretion to keep within the limit, or sufficient money or property to take care of his mistakes. It is not necessary that an officer take any risk, as in questionable cases, he can decline to execute the process or require a bond to indemnify him against loss. United States Marshals are appointed by the President and are generally men of good standing and are able to keep within their rights. In cases of doubt, they can consult the district attorney, and in many offices, there is a chief deputy who has been holding from term to term, who is thoroughly conversant with the rights and duties of a marshal. As a rule, a United States Marshal is a good risk without regard to his financial responsibility. The same general observations might be made with regard to sheriffs in large cities and counties. and there is little danger that a sheriff of this class will exceed his authority to the extent of imposing a liability on himself or his surety. Nearly all losses on sheriff's bonds occur in the country districts where the sheriff is likely to be unfamiliar with legal process, and the extent of his powers, where he personally does the work, where there is no attorney to advise him, where the only compensation is in the shape of fees, and where, in order to make a fee, he will sometimes take a chance. Sheriffs of this class should not be bonded unless their experience and training are such as to reasonably qualify them for the office, or unless they have some property subject to execution. If they will lose anything by acts in excess of authority, they are likely to keep within a limit. The same remarks would apply to deputy sheriffs and others who personally execute the process in the larger offices. However, these men are as a rule under the close supervision of their chief, who can generally keep them straight, and the risk is not considered particularly great, and financial responsibility is not absolutely necessary, although of course desirable. It often happens, however, that in cases of strikes or other disturbances, a large number of special deputies are sworn in for the purpose of maintaining order. These men are paid by the employer, and, generally go the limit in enforcing his orders. Where the feeling is tense between the employer and employees, and where the strikers are a rough class of men, such, for example, as miners, the risk is generally bad, and the application should be declined. Constables, or city marshals, as they are called in New York City, and some other places, are bad risks and are rightfully on the prohibited list of surety companies. In the first place, a constable is generally a low order of politician with little or no money and less brains, and who, having been unable to get any other position, accepts that of constable as a last resort. In the second place, constables are given the undesirable collections of loan sharks, installment houses and the like, and being hard up for fees and having nothing to lose, will generally make seizures regardless of consequences, as long as they get the fee. The surety on such a bond is in constant danger of damage suits,